All right, good morning, everyone. Thank you for joining. Welcome to LCCHP's third lunchtime webinar. This one is going to be on Holocaust art restitution issues, and I'm going to go ahead and pass it over to our president, Tom Kline, to introduce our panelists.
Well, good afternoon, everyone, and welcome. Thank you so much for your interest in this Lawyers Committee for Cultural Heritage Preservation panel discussion. As you can probably imagine, our annual conference last year fell to COVID, like so much else. So we've resurrected this panel discussion. I want to thank our speakers for joining us today. You may know them well. Just to give a short introduction, Monica Dugot is an independent consultant working in the area of restitution. She's been working at it since the 90s, first at the Holocaust Claims Processing Office and then at Christie's. While at Christie's, she worked on at least 200 settlements of Holocaust-related claims. Pierre has his own law firm, works on restitution matters both in the United States and in France, and has been primarily on the claimant side. Bill Charron has been partnered with Pryor Cashman, also teaches at University of Virginia, where I had the honor to join him one time. He's worked on some of the most important cases on the defense side, most important case for the last 10 years. What we had in mind for today was three different perspectives. So I think of this as three TED Talks, not just a panel discussion, but you can think of it however you like. We're using the TEDx format, which is intended to give freedom to the speakers to be more personal, talk about their own experiences and observations. We have a lot of law students signed up today, and I know you always like to hear about how people got to where they are and maybe how you can get to where they are since 10, 20 years from now, you'll be handling this area for us and we'll be watching. Your questions will go to Kate, who will try to combine them and winnow them and feed them to me. So once our speakers finish up, we'll try to have a Q&A period. So without anything further, I'll just hand it off to Monica, and from her to Pierre, and then to Bill. With no further ceremony, you can just pass it on when you're done, Monica.
Okay. Thank you, Tom, for organizing this webinar. Thank you, Kate. You can all hear me fine? Can you hear me? Hi, can you hear me?
Yes, you're good.
Oh, okay, good. Sorry, just wanted to make sure. Great. Perfect. Well, and thank you all for joining us here today. I'll just launch in. My family is from a part of the world that no longer exists in the way it once did. Vienna, Krakow, and other places in Central Europe were once centers of a vibrant Jewish culture. There are still cities with those names, but the names are all that remains of what the Austrian novelist Stefan Zweig referred to as a world of yesterday. These are my maternal grandparents and my mother. They came from Vienna, and like so many others, were separated from their homes and their
Monica,
community.
we can't see your slideshow yet.
You can't, okay. Let me, hold on.
You go to the bottom of your screen, it should just say share screen.
Which is what I'm doing, but all of a sudden, hold on one second. Let's see what's going on here. Let me try this one more time. Just disappeared off the screen. Just give me 2 seconds. So strange it was working. I don't want to end the meeting for all. So, which it seems to be,
Did you send me your PowerPoint? I can go ahead and do it.
no. 1 second. Just trying to get it up. I might have to just get out of this and then something's happened. So,
Okay, switch me over to host. Sorry,
the whole thing is frozen. Just give me 2 seconds.
Lovely.
Let me just,
No, you're fine.
yes.
You're fine.
Wonderful. Here we go. Can you see this slide or not?
No.
No. Boy. I'm going to have to, I'm going to, give me 2 seconds. I'm trying to share, trying to make you the host. And you still can't see the screen? Because it's,
Nope.
something happened when you switched me as host. I'm just trying to, I might just try to call back in because otherwise I think this is pretty frozen at the moment.
Okay. When you push leave, just don't push end for all.
Got it.
All right. Perfect. So I guess let's go ahead and switch up the order so that Monica can get.
Yeah, so Pierre, why don't you go ahead?
Sure. Do you want to switch me as host just so I can share my slides?
Yes, Monica, can you do that?
Oh, Monica, you're gonna have to do that, right?
Right.
You go on the name.
All right, there we go. I am host now.
Okay,
right.
so Kate, you're gonna have to switch me.
You are now host.
Okay.
Sorry for the technical difficulties.
That's okay. Can people see?
Yes.
Can people see the slides?
Yes.
Okay. Good afternoon, everybody. I guess we're switching orders a bit. So my name is Pierre. I come from a very complicated Jewish family that came from 3 branches, one out of Czechoslovakia, another one from Alsace, and the third one from Italy. The Italian branch and the Alsace branch were both art dealers between 1860 and 1939. So all of this area of Nazi-looted art restitution is obviously very personal, with some of the family members dealing with some of these claims, obviously not in the United States, but in France. I'm going to really focus on, since there's a lot of practitioners and students in the audience, really focus on very practical considerations as to, in terms of these cases, if anybody in their future or near or very near future is exposed to these cases, what kind of practice concerns they should have from a very practical standpoint. 2 problems, obviously. One is everything that can go south on you will probably go south on you, according to a very famous legal principle called Murphy's Law. And you're also dealing with a very traumatic area, a traumatic period in history, which makes these cases, we'll see, more difficult than the average to deal with. So these are the issues that we're going to do a quick review on, really from the standpoint of comparing this type of practice to a traditional practice such as, wills and trust, or a tort practice like medical malpractice, practices that are much more stable than obviously this particular area of the law, which you will see is clearly not as stable. The first set of issues has to do, and this is kind of the normal life cycle of a case, when you're, and in fact, first, a lot of these remarks are probably very well adapted to cultural heritage cases beyond even Nazi-looted out situations, since a lot of these issues from a practice standpoint tend to be very common. So if we look at intake issues, which is the first phase of anyone, in fact, both defense and plaintiff side kind of looking at a case that comes into the firm, the first issue is to kind of look at it from the standpoint of risk management when the intake process takes place. By the way, if you don't have that face of this particular legal lawyer on the side there in the photo that you can see, you don't have that face when you do the intake process, it probably means you're not doing enough work on the intake process itself, because it is quite a grueling process to really evaluate the risk for any case in general, but most specifically in this type of situations. You can see here a lot of the issues that are typically involved in risk assessment. In Nazi-looted out cases, practically every single one of these is going to be an issue to look at. But really the matter analysis, which is really the matter itself, that I want to talk a little bit more about, because it really forces the practitioner to really go back in history and figure out what the provenance of the object that's being challenged in terms of the case is, which goes back to a very big part of what lawyers were not good historians, not that historians are good lawyers, obviously, but lawyers are not good historians. And obviously the focus here is to really look at it from the standpoint of, you really have to go back and take the historian hat for a bit and figure out where the object came from. Because without that, you have a claim involving title. And so you really have to reconstitute the title picture with a window of time of 75 years. In fact, sometimes longer, because you have to go back to prior to World War II to figure out where the object originally came from. So provenance is obviously, you see probably a lot of people talking about what the heck is provenance research. Well, you know why now? Because you have to carry that hat and figure out for yourself, in order to make appropriate claims, what that provenance is. So since lawyers are not good historians, get one. That's the idea, because obviously there's an awful amount of questions to go back to evaluate in terms of where the object came from. And so you have here a bunch of examples in terms of how you reconstitute the history of the objects. I'm not going to go in detail through those, because you can just do a class on probably a whole semester on provenance research, right? But we're not going to do that here. But these are some of the questions that have to be raised. Here's some more here, and you can see a lot of it has to do with whether documentation exists, which creates the question: if you don't have a lot of documentation, what kind of red flags associated with the history of the object are there to at least give a context as to where the subject went through in order to make a determination as to its title. So you have, but this is a process that you have to really do with a historian in order to really get a good handle on it. The good news with World War II, if you accept Eastern Europe, which basically has very little documentation, is that as to the western side of Europe, there is tons of documentation. So archives of all sorts, there actually there's a good set of a good amount of work that one can do to really reconstitute the title picture of the object. One big issue that I think you're hearing a lot about these days is the emergence of the online tools. Don't get fooled by that. It's not because you have suddenly all sorts of provenance databases that you can do this with your PJs from your house. You have to get your hands dirty. The reason is there is a progression of these online tools that only cover a certain universe of data of archives. So very often when you're dealing, and I take the example of France as a very good one, because France has really made big progress in terms of putting a lot of archives online, it really becomes a puzzle because half the time you actually have to physically, or you or the historian, have to actually go and physically go through these fonds d'archives or archival sets, sometimes in the United States, sometimes in Germany, sometimes in France. So you really have to actually go and get your hands dirty with those and combine that with what the online tools is doing. So it's really becoming more of a puzzle situation to amass both and to kind of bring those together to figure out the picture, rather than saying, gee, I can, online tools are there, that makes the job much easier. It really is not the case here. So that's really the intake consideration. The second set of issues I wanted to talk really very quickly about is the litigation process itself. There's so much we can talk about. Two issues really that I wanted to focus on is first the legal doctrines. The legal doctrines are basically the opposite of traditional practices. Say you do a med-mal case in New York, right? Your rules are set in stone, notwithstanding jurisprudential changes, notwithstanding what the legislature is going to do. You're dealing with a very stable universe of rules. That's not at all the case in this particular situations. To pick up an experience from Tom, the restitution roulette continues because you're really hitting doctrines that are really not very well set in stone. There's a list of examples here. Statute of limitations is one. The laches doctrine came back again in a more recent case. The FSIA statute will take a look at. I mean, there's all sorts of doctrine that are not set in stone. Essentially, the field, at least in the civil side in the United States, even though there's been cases, there's been jurisprudential activity on these cases since 1945. A lot of influx really has come since 1998 after the so-called Washington Conference that really brought together all of these countries on restitution issues involving asset classes way beyond art. But it really it's a relatively, I don't want to say young, it's not young, but more recent activity that makes the pool of cases fairly unstable. Here's an example here, which is the statute of limitations. As you know, this is a state-based rule for most cases, but that has now become a federally set rule for specifically Nazi-looted art cases since the passage of the HERE Act in 2016. So you really have a lot of layers that you have to look at. By the way, the passage of the HERE Act focuses strictly on Nazi-looted art cases, which means that a traditional cultural heritage case would still be governed by the state rules. So you really have to kind of mesh in all of these different factors. And obviously, that's something that forces practitioner to raise a lot of questions as to how do you even come up with the statute of limitation answers, since a lot of it is based now on what the actual knowledge, when was the actual knowledge of the object being located at a certain location was acquired. That alone is probably raising questions that have not been resolved. So again, unlike your med-mal situation where the practitioner knows exactly where the line is, because that raises ethical questions and practice questions if you go beyond what the rule says. Here, a lot of it is much more fuzzy. So that's an example for discovery. FSIA is another example. FSIA stands for the Foreign Sovereign Immunities Act. Very often, parties, both on the plaintiff and the defendant side, in fact, are government entities, because a lot of the museums in Europe, in fact, most, if not all, of the museums in Europe, since often enough, this will involve a museum that comes out of Europe, since a lot of the looting obviously took place in Europe, are foreign sovereigns, since they are all owned by governments, which means that the FSIA, that's the reason why you see the FSIA pop up all the time, which is one of the issues that was tested yesterday during the Philip versus Germany case that was heard on oral arguments at the US Supreme Court yesterday, which is another example that these things are really not a very settled area of law, especially if you have to sit there for 3.5 hours hearing, Supreme Court justices, bang around the doctrine for all this. So another practice pointer for anybody that's going to get exposed to this in the future: nothing legal. Not everybody likes to deal with the press. Okay, the media is not. Sometimes people are not comfortable with it. You really are not going to have a choice here. The media loves these cases, devours them with fury. So you're going to have to deal with it, whether you're on either side, in fact. And so that's not something you learn in law school, obviously. So one of the issues you're going to have to deal with is develop a strategy, because they're going to call regardless. So you're going to have to kind of figure out a way to manage that. You have to basically do like a PR firm, which is develop a media strategy as to how you address the media field, what kind of questions you answer, etc. It's not a bad idea to get a professional to help you out, because you have to take this thing seriously. And 3 is, based on my particular experience of these cases, the media really, they're more interested in the facts than really the legal doctrine. The legal doctrine is really for lawyers. They're absolutely fascinated by the notion of how come all of these stolen objects, how come what Hitler did 75 years ago still resonates today in terms of a collector, of a museum in the United States or in Europe. How come this thing is not settled and it's 25 years, right? So you have to educate. There's a lot of education, very basic education to do with the media as to why, because believe you me, they will be at your door, sometimes even before you file, but the moment they file. I mean, in one example, I think I filed at 11 o'clock, and by 11:15, I got the first phone call, because these, darn things get loaded automatically, right? So they're going to be around, figure out a way to deal with that. In terms of resolution issues, towards the end of the case, and we're trying to resolve a case, right? One thing you have to keep in mind in terms of the Nazi looter cases is that the plaintiff side essentially is a class of folks which are essentially really impacted by the survivor syndrome. You're typically dealing with 3 groups. The first group is the first generation survivors. There's not, unfortunately, a lot of them, since they would have been in their Middle Ages during World War II, but you're dealing mostly these days with 2 other classes of folks. One is the children, the folks that were children during the Holocaust. So now they're in their 80s, 90s, and they're the ones who are usually that you see on the plaintiff side. And you're also dealing with second generation people, which is essentially descendants of people that have been directly exposed to World War II. In all of these cases, you're going to deal with some form of syndrome-driven issues. You probably want to educate yourself with what PTSD issues are, because you're going to have to absorb and resolve a lot of the you're gonna have to manage this in a way that that is consistent with where the plaintiff comes from, because you will experience these characteristics of trauma one way or the other, even for the second generation. So you want to equip yourself with what exactly does that mean? What kind of trend do you see? Sometimes, you know, these issues here you see, anxiety, depression, let's say strong emotional reactions, they will be there across the board in some way, shape, or form, but they will be there. So you want to, don't be surprised by them because they will hit you. So that's something to kind of think through to be able to be successful at this, because it really impacts how you address a whole bunch of questions in your case. First, you know, when you start interviewing people, survivors or children, you know, survivors that were children, not everything is going to come out. You're going to remember things not necessarily the way they were from an objective standpoint. So it impacts how you flush out the facts initially, which is why this archival research is so important and the work with the historian is so important. It impacts also how you define success with these folks. What is success for a case? Win the case, what does that mean? Get the object returned, of course. But it could also mean all sorts of other things, such as, you know, acknowledgement, recognition. A lot of it has to do with the acknowledgement of what happened. So that's a lot of what the emotional journey is for survivors. A big focus on that this, or a big consequence this has, is really when you're trying to resolve a case. Let's assume you're in a situation where a mediation is possible. Doesn't happen very often, but a mediation scenario is possible. How do you go through a process like this with somebody who's really, really not in the mood to sit down with the other side? Because they really are not. So there's this perception of, the other side. A museum in the U.S. is usually stuck with what's called a good faith purchasing doctrine, which is they're facing the claim as the first entity that acquired the object, but they're not part of what happened during World War II. So you have a lot of emotions on both sides. One side wants revenge. Very often there's that piece of it, or at least some form of acknowledgement, or at least some form of recognition. And then the other side is like, well, why me? I just acquired this thing, this object in good faith. Quick point of practice: good faith is a defense, in fact, in Europe. It's not in the United States. So you can imagine the reaction that a lot of these collectors or these museums end up having. Very quickly, from the standpoint of, if you ever have to deal with organizing a mediation, don't have the direct parties in the same room. It just is not going to work. You want intermediaries, family members. Sometimes that works. Lawyers, mediators. On both sides, you really need other intermediaries. In fact, it's one of the situations where the biggest distance between the parties is probably the better situation. So at least some reasonable conversations can take place. One good news with this particular area is the way property rights in Europe versus the United States place is that there's not a lot of variety in property rights in Europe. It's either you own or you don't. The US is much more, has a lot of, it's called a bouquet of rights, French word. I'd say this is really, there's a lot of different aspects to possession, title, which allows for a lot of creativity. There's a lot more creativity possible with these cases than the usual, which is usually how, that's one thing you want to keep in mind when you're trying to find resolutions in a very psychologically complicated landscape. So a very rewarding practice. You're dealing with a lot of history in your hands, but it will stretch your the limits of your practice and of your brain, because there's a lot of things you're going to have to deal with, obviously, beyond the traditional legal practice. Thank you very much. Do I do something with, do I transfer? Do I move over?
I already took care of it. So I
Oh, okay.
will switch.
So I don't need to
over.
send it to.
It should be good. Okay. We should be able to see Monica now. Good.
Unmute.
Right, all kinds of issues, but here we go. Can you hear me and see me?
Yeah, there you go.
Okay, now I'm going to try to share the screen one more time, and hopefully this will work. I apologize for all these technical problems. So it says the host disabled participant screen sharing. Good.
I am making you host now.
Thank you very much.
All right, you should be host now.
Great. And can you see my screen?
Yes.
Okay, fantastic. We're in business. So apologies for the technical difficulties before. Just to start one more time, I think I might start just from the beginning to just let you know that my family is from a part of the world that doesn't exist anymore. Places, Vienna, Krakow, and other places in Central Europe that were once centers of a vibrant Jewish culture. I am just, here we go. These are my maternal grandparents. They came from Vienna, and like so many others, they were separated from their homes and their communities when the Nazis took power in Austria in 1938. Unlike so many others, they survived the Holocaust. They became survivors, but surviving was a struggle. They were separated from my mother, who was only 2 years old at that time. My mother ended up in the Warsaw Ghetto and was smuggled out and hidden by a devout Catholic woman who raised my mother as Catholic in Poland for the remainder of the war. These are my paternal grandparents. They came from Sosnowiec in Poland. My grandfather and their daughter perished in Auschwitz. My grandmother and my father eventually made their way to the States via Stockholm. For my family, as for so many from this world of yesterday, this was a time of indescribable suffering and loss. And it may then be a relief to know that my parents found each other one Labor Day weekend in the Catskills, and they started new lives in America. When I was growing up, my parents sometimes spoke of what had happened in the Holocaust in opaque bits and pieces here and there. But how could I, as a child, piece these snippets together and really grasp the reality, the magnitude, the horror of what had happened, what they had experienced, or what had been lost? As fragments of memory and vague recollections, it was all intangible to me. What was real to me, however, what I remember very clearly was my maternal grandparents' New York City apartment. It was small and jam-packed with objects, reminders, and replacements of this other time and place. There was also an old bridge table piled high with papers. And these papers were in fact partial records of what my family had lost. Papers painstakingly collected, attempts to document what had become of their old life in Vienna, their home, the paintings, their books, most of it all gone. Today, I work in art restitution, specifically looking at the movement of art looted during the Nazi era and how that art has been dispersed throughout the world. It may not have been what I'd planned to do after college and law school, but in fact, it feels predestined. An opportunity arose. I went to work on what was to be an 18-month project for New York State, establishing with others the work of the Holocaust Claims Processing Office in 1997, and helping families trace and recover assets lost as a result of persecution or displacement, largely by the Nazis. Then for 16 years, I oversaw research into the provenance or history of artworks Christie's offered for sale globally and resolving claims where these came to light. I now serve as United States Attorney on the Foundation for Remembrance, Responsibility, and Future, which was established in August 2000 2 years after the Washington Conference, and which promotes human rights and understanding between peoples with a commitment to the victims of National Socialism. I'm also delving further into my own family story, and I continue to be involved in a number of art restitution projects. The story of the great planned Nazi art looting operation and the inseparable link between that looting and the persecution of Jews and others viewed as enemies of the regime has really come to the fore in the last 25 years. It's not an accident. Events like the class action lawsuits in the mid-90s against the Swiss banks for monies not returned to survivor families of the Holocaust, the advent of the internet, newly accessible archives, and so on made the world aware of still open issues. This new awareness has worked its way into popular culture and mainstream news reporting, be it on the big screen, a recent film release entitled The Last Vermeer, or Helen Mirren in The Woman in Gold, George Clooney's The Monuments Men, or even international press headlines, which regularly, almost daily, include stories of paintings with newly discovered histories or descriptions of a particular family's renewed search for lost and looted work or collection. In the United States and much of the Western world, there's still a real fascination with the Nazis and their actions, an unfinished chapter even 85 years on. These films and stories are popular because they offer up some hope, perversely, of a partially happy ending. The story of an ordinary woman living in exile from Austria, winning against the might of a foreign state to reclaim magnificent paintings looted from her family's Vienna home. A fearless bunch of dedicated and good people, the Monuments Men, who are art historians, museum directors, curators, seconded into the army, working to find, protect, and recover art, even while the war rages around them. These films and their narratives offer up a sense of islands of justice in a sea of evil. It's tapping into something deep in us as humans, this need we have to see wrong put right. I'm very lucky that in my working life, I get to do exactly that, help families and collectors navigate the complex waters of ownership and restitution, to help at least some individuals win back a portion of their family heritage that they believe was stolen from them. To do so, they must often battle against a world that prefers to move on and accept the status quo, rather than try to undo the theft and displacement of the individual's heritage. Not all claims are valid, however, and my work sometimes clears paintings. Art restitution work is a privilege, a responsibility, a challenge. It's an intellectual puzzle. It's a bit of detective work. It's trying, confrontational, misunderstood, redemptive, conciliatory, and surprisingly joyful. Restitution is about justice and balance. While addressing the wrongs of Nazi art looting, we must recognize that restitution is not a simple task. Art, an easily traded and transported commodity, could change hands legitimately through a good faith transaction, depending on geography and jurisdiction. A painting can also change in size, shape, and appearance. And where that may have happened, or where that object has become as much a part of other families' histories, it's a difficult and sensitive task trying to unravel competing ownership rights. This Egon Schiele Wilted Sunflowers, which along with my colleagues at Christie's, I helped restitute to the present day heirs of its original owner in 2006, is a good example of how the process can function. This work, which was painted in 1914 around the time of the outbreak of the First World War, is so expressive, so loaded with sadness. It seems to foreshadow the end of a golden Vienna, which was at that time the center for intellectual and creative activity, much of which was Jewish. And the beginning of the loss, the debasement, the dismantling of homes, lives, and a culture that would take place 20 years later. The problem was found through a routine request for an estimate. The Schiele had been inherited by someone with no idea that the painting in his possession was a lost masterpiece. Neither was he at all aware that it had in fact been the jewel in the crown of the Grünwald family collection in Vienna before Hitler's annexation of Austria, the Anschluss. Karl Grünwald, the owner and an art dealer, had shipped wilted sunflowers to France in 1938 following the annexation, but the work ended up being confiscated in France as Jewish property and later sold off. Grunewald managed to escape Europe and found his way to the United States. Although not all of his family made it, his wife and his daughter were killed. Grunewald's search for this lost work had been passed down through the Grunewald family through 3 generations. And news of its rediscovery, as you can imagine, was bittersweet and life-changing for the over 20 or so surviving family members, as well as for the then owner, who wholeheartedly agreed to an amicable settlement of the question of ownership. Art restitution can be very difficult. For every success story, there are those quests for property that can't be found. There are many obstacles that stand in the way of a family's efforts to find and recover their lost art. A large number of these obstacles are related to the passing of time. Artworks are sold on and traces of them are lost. Documentation on ownership is hidden and lost, or memories fade. The law in one country might not allow an ownership after a period of time has passed, or there has been even a good faith purchase. Many current possessors of looted art are acting in good faith, having bought or inherited the object with absolutely no knowledge at the time of its tainted history. So the equities are not always clear-cut. At times, the work I do involves masterpieces, but more often than not, the artworks or the claims I work on are for very much more modest, even mundane objects. Restitution work includes the types of objects found in many homes: paintings, books, Judaica, porcelain, furniture, even musical instruments. Objects like those my family and perhaps your families chose to collect or to use, to look at, to read, or to display. But collectively, they tell us so much about a lost society and a world that disappeared. We're all fascinated by our own family's history, which in a very real sense makes us who we are. Having something that belonged to a grandparent or a great-grandparent centers you and immediately transports you to an intimacy with that person and the world that they had inhabited. Sorry about that. My maternal grandfather set up an antique shop on the east side of Manhattan soon after he arrived in the United States from Vienna via Palestine and Paris. The antique shop was called Mayflower Art Galleries. He loved to collect beautiful art objects and antiques from a world gone by. He was proud of his adopted country. Honestly, what could be more patriotic than calling your shop Mayflower? However, I'm sure that buying and selling antiques was really his way of making sure that the world he loved so much and that he'd been such a part of would not be forgotten. And he also surrounded himself with these objects in his own home. Perhaps it's no coincidence that I work in a field where I too have access to beautiful objects, where I delve into piles and piles of historical documents and records, and where, as part of my work, I get to travel to places that will have meant something to him and to my family. The vast looting of artworks and possessions by the Nazis was not just greed or aimed to strip Jews of their assets in Germany and in occupied countries. This looting wasn't a sideshow to the main genocide, but it was very much part and parcel of it. By looting cultural objects, the Nazis intended to wipe out a collective culture and its memory. It disconnected people from their history and their roots. It sought to dehumanize a people. To be rooted is perhaps the most important and least recognized need of the human soul. Holocaust survivor and stateswoman Simone Weil once commented, "Despots have known since the beginning of time that uprooting and dehumanizing those who they want to vilify is essential to that process." Through provenance research and other restitution efforts, we can acknowledge the original owner's existence, by taking away art and possessions, laundering them through the Nazis' looting and marketing machine. Ownership and any cultural connection is for the most part eradicated. Names become uncoupled from objects. Artworks were just passed on hand to hand, dealer to dealer, and with no physical documentation, any sense of ownership is lost. Complicity or secrecy or amnesia about the fate of former owners even became the norm for the circulation of many artworks during wartime and even post-war. The idea of restitution in its simplest sense is that something that was stolen is given back. The process and act of restitution is a way of hearing people's stories and connecting us to our past. It makes the 6 million lost not just a number, but gives names and stories back to people and their descendants. Restitution also helps children of survivors turn from victims into protagonists and gives them the power to take back control of how their history is written. Restoring culture, restoring memories, and resolving claims for looted objects means that stories are restored and wrongs are righted. Working in art restitution helps me understand and reclaim part of a history I didn't know firsthand. The fragments of remembered events I heard as a child have now become, for me, part of a much larger story. And by reconnecting objects with their rightful owners, we're acknowledging the owner's existence and therefore what the Nazis tried so desperately to take away, the citizenship and humanity of those people and their descendants. Again, none of this is meant to prejudge any particular claim or to say that every restitution claim is valid and must be honored. The hard work of restitution means that we must delve deeply into the historical circumstances and examine the current legal context to see where justice lies today. Especially memorable for me is a painting I worked on in 1999 together with my colleagues at the Holocaust Claims Processing Office. The painting, Lesser Yuri's A Seamstress, had been owned by a Berlin collector, Louis Lowenthal. With our assistance, the work was restituted to his grandson, Michael, after 52 years and now hangs in his living room. As Michael commented after its restitution, it's after all the only thing I possess from that part of my past. The work was one of many valuable paintings in the collection of Louis Lowenthal. Late in 1939, anticipating deportation, Louis arranged to raise cash by consigning his collection under duress to art dealer Wolfgang Gerlit. The understanding was that in addition to upfront cash, Gerlit would ultimately pay the fair market value of the works or return them after the war. Louis Lowenthal unfortunately never made it out of Germany. He died in 1940. In 1947, Fritz Lowenthal, who had managed to flee to London and then Palestine, began attempts to recover his father's collection, including the seamstress, or alternatively, a payment for the balance of the transaction. In correspondence initiated by Fritz, Gerlit told Fritz that most of the paintings had actually been destroyed in an air raid. This turned out not to be the case, and as early as 1951, the seamstress was on view at the Neue Gallery in Linz, having been officially bought by the city in 1956. The story of the Lowenthal's dispossession and that of other families illustrates time and time again how art looting was closely linked to genocide, not only in the annihilation of cultural identity, but in draining the assets of the victims. In this instance, with a close review of the painting's provenance and a discussion of the facts, we together addressed the dark history of the work and restored the painting to its rightful owners. What made this restitution particularly meaningful underlines that restitution work is not about the headlines and about the masterpieces. It's about restoration of memory. The return of the painting was gratifying for Michael, as this was not simply about restoring an artwork to a family that has long sought its return. Through this journey to recover his grandfather's painting, Michael was able to begin the often very difficult process of sharing family history and stories with his own family, and especially with his teenage son and daughter. I continue to count myself extremely privileged to have a window into the lives of collectors past and to be able to assist where I can. It turns out that the apple hasn't fallen too far from the tree, and I really am my grandfather's granddaughter, and my work, like his antique shop, is a little piece of making sure that no one forgets. Thanks. Do I now, I will now pass this on to Bill, or do you do that, Kate?
You can, either way, it's up to you.
Why don't you do it, given all the issues that I had?
Okay,
I think
so
everything's fixed, but let's not take any
end
chance.
your share screen.
Okay,
And
we're
then
just
all
gonna
you
do
have,
stuff.
Perfect,
Right.
perfect.
There you
And
go.
then- And then time to switch over. All right, perfect.
All right, great. Thank you very much. I just want to start by saying I think it's really encouraging to see there's a lot of stories in the news right now about this topic, and there's a lot of attention and I think initiative to try to drive people to focus on the core question of obtaining just results. And then the question becomes, well, what does just mean? I think Monica just said it really well. Something that was stolen should be given back. And I think at a just most elemental level, just means that you can feel comfortable that there was a Nazi theft here, deserving of some sort of action. Just does not always mean that you would take a work of art from its current good faith possessor, though. And that's really how I've gotten involved in these cases. I've been involved in these cases on both sides, but as Tom mentioned at the start, I've probably been gotten a bit more attention on the defense side, which means representing good faith current possessors. My introduction to these cases came about 15 years ago in a case that involved a situation where you really didn't have the evidence of Nazi theft. And despite that lack of evidence, this was a case that went on through every level of the federal courts for over 8 years. And so, I happen to be Jewish. I don't have the same personal connection to these cases as Monica and Pierre, but I was, of course, drawn to them. The cases are, beyond compelling and gripping factually, but also legally. Particularly if you are interested in the kinds of issues that get involved, which primarily concern property rights, sales law concepts, and an awful lot of civil procedure and evidence. You got to love those topics if you're going to practice in this area. But the case that I got started in was a case called Bacalar v. Vavra. It was a New York case. And as I said, it kind of shows what happens if the evidence no longer exists, meaning that the people who were witnesses to the transactions have deceased and most of the documents are gone, but you have heirs or successors who are very determined to litigate the claim. And what can often happen in those situations is that those parties are forced somewhat to speculate. Sometimes that speculation can become quite zealous. Sometimes I think it can become overzealous and even extreme. In the Bacalar case, basically what we had was a documented Holocaust victim who was a known collector of Egon Schiele art, among other art. And our case concerned a particular drawing that our client had bought in New York in the 1960s. The drawing was traced to a Swiss art dealer who had it in the 1950s. And that Swiss art dealer had preserved his records, and those records showed that he had acquired it from a woman who was the sister-in-law of the Holocaust victim. And so at core, it seemed to be, not a terribly objectionable proposition to say that if the sister-in-law had it after the war, then the Nazis didn't steal it during the war. That was pretty much the case, at least on one level. And so that really called into question the credibility of the Swiss art dealer. The sister-in-law had passed away. Her name was Matilda Lukash. She had passed away, but the Swiss dealer was still alive. He voluntarily participated in discovery, which if you're a Swiss citizen, you don't have to do. He did it voluntarily, and he produced all his records, which he had meticulously saved. And so what I'm going to do is I just want to show a couple of points. So let me just make sure people can see what's on the screen now. Yes?
We don't see your PowerPoint.
You don't see my PowerPoint, okay? Because it says I'm screen sharing.
Right.
Okay, I'm going to try one more time, and then I'm going to.
Happened to me.
Did that work?
Yep.
Perfect.
Okay. So again, the Swiss art dealer, whose name was Kornfeld, Eberhard Kornfeld, had saved all his records, and he had records of correspondence with Matilda Lukash that spanned a period of 4 years during the 1950s. And they corresponded regularly. And within that correspondence was communications from Lukash to Kornfeld offering to sell him a collection of Egon Schiele art, which included the drawing that was at issue in our case. And Kornfeld had his handwritten inventory ledger showing his acquisition of the drawing and ultimately his sale. And so what the heirs of the Holocaust victim, whose name was Fritz Grunbaum, claimed was that Kornfeld had fabricated all of this. This entire story about his dealings with Matilda Lukash were supposedly a lie. He'd forged the correspondence and he'd made the whole thing up, and that he was actually a Nazi fence. And it's fine to raise that theory, but I just want to give you a little taste of the kind of evidence that we were looking at. This is one of the letters from Matilda Lukash to Kornfeld back in 1952. And this was a letter that talked about how, as I said, they corresponded regularly. This talked about a number of matters, but one of them was that Lukash had recently moved apartments, and her new mailbox was too small to hold Kornfeld's catalogs. And so she asked him to please send his catalogs to a different address in the future so they would fit. And the notion, and this had nothing to do with the drawing or any sales, it was just correspondence. And the notion that Kornfeld would have invented this and fabricated this, decades earlier, there was a bridge too far element to that theory. This is another piece of correspondence. This is a postcard from Lukash to Kornfeld, and you can kind of make out stamps and postmarks that don't exist any longer. And so again, Kornfeld would have had to have invented this stuff decades ago, all with the idea that maybe one day this would be called into question. And so he would, there's criminality, there's criminal masterminds, and then I don't know what this would be, but it would be way beyond. And my point being that, I think in this was my introduction to this field of law. And I found it to be a kind of prosecution that can really go too far and reach the point of true unfairness to the current good faith possessor who has done nothing wrong. And this is not the only case. I mean, I've had a number of these cases when I get involved on the defense side. It's really because of a sense that there's real overreaching and over speculation on the claimant side. This is a case, this is a painting by Paul Kline, and this was a case where a collector had fled to escape the Nazis, had entrusted his art, and after the war tried to reclaim the art and was told that it was all gone. And he made some claims after the war. And he identified works that he was seeking compensation for. And he identified a work by Paul Kline. And so on the left of this screen is the painting that was in my client's possession. Maybe it's not the greatest image, but you can kind of make it out. And on the right is the description that the collector had identified in making his compensation claim. He said that the clay painting that he had involved, quote, some kind of winter landscape, white and light blue segments of snowflakes in which little figures and signs were written into. Above this, a matte blazing moon disk. So that's from the collector himself. And, again, you may not be able to make out the entirety of the painting so well, but there's no matte blazing moon disk. There are no figures, there's no snowflakes. It's not a winter landscape. There are warm colors. It's just not the same. And yet this was pressed very, very aggressively along with other claims and other works for a number of years. And there's another case I'm involved in at present, which deals with an artist. Pierre made a point about you want to go out and get a historian. And I agree with that if it's practicable. This is a case where our client, current good faith possessor, owns a work, went out, engaged a historian who went to the relevant archives, really researched, and was able to trace the provenance of the work that our client has back to the artist himself. The work involves a figure in a red dress. And so a claim was made that someone owned a painting by this artist, and it involved a figure in a red dress. If you look at the artist's oeuvre, you see that the artist, there are probably no fewer than 25 works with women in red dresses. And so when you just prosecute on the basis of, well, there's that sort of commonality, and you don't address the work that a historian has done and the provenance research that has gone into it, I think, again, it can become overzealous. And what kind of inspires me in these cases is that this becomes really unfair for the current possessors. It becomes very, very expensive. I've seen some questions already in the chats, and Pierre and Monica have noted this as well. These cases, and I have as well, these cases can go on for years. If you're on the defense side and you're having to defend against claims that reach the level of being too far-fetched and too speculative, but at the same time you have to. And in this country, we don't have fee shifting, unlike in Europe. And so there can be an element that, well, maybe this will just become a war of attrition, and the current owner will kind of be worn down and will agree to settle at some point. I think that is certainly, I don't mean to say by any stretch that that's the way these cases commonly go, and certainly not the way they should go, but they can go that way. And I think that some of the more higher profile cases that have gone to court decisions and have gone in favor of the defendants, of good faith possessors, are often a result of the lack of evidence on the claimant side. But it takes a while to get there. And so for me, these cases introduce real due process kind of concerns. Basically, at core, I think that both sides have the right to put on a meaningful case. These cases should involve meaningful presentations of evidence. And again, coming back to this question of, can you have comfort that there was a theft here or not? One of the key principles that came out of Bacalar, and Pierre talked about this, is the laches defense. And so what the laches defense basically says is that if the victim or the victor's heirs or successors really knew or should have known about lost or stolen artwork and did not make a timely claim and allowed evidence to disappear, and that evidence has really disabled the current possessor from being able to put on a meaningful defense. Again, it implicates due process concerns, I think. Laches will come in and say that's not an equitable result. And Monica said it well. Again, she said the equities are not always clear cut. I agree with that. And that's where laches really comes into play. This is the quote from Bacalar. However, laches is applied in this case, it will work a certain inequity on the losing party. And this court is in the unenviable position of determining who gets the artwork and who will be left with nothing, despite a plausible claim of being unfairly required to bear the loss. That I strongly agree with that description of the laches defense. When laches comes in and has to sort of settle a dispute among two sympathetic innocent parties, the alleged victim or the successor or heirs of that victim on the one hand, and a good faith current possessor on the other hand. And this is, unless the parties are willing to mediate, monetize the art, split proceeds, only one side wants the art, the other wants money. In those situations, you can mediate a resolution. But if both sides want the art, then this is a zero-sum game. There can only be one winner. And in a situation where you don't have, if you're on the defense side, you don't have the ability to put on a meaningful case, laches comes in and kind of supplies the rule of decision. It fills that void and it says, look, one side has to lose, one side has to bear the risk of loss. Who should more justly do that? And I will tell you, as a student of UVA Law School, which taught from this law and economics kind of philosophy, of societal burdens and how to assign risks of loss and burdens of diligence, Latches fits squarely into that analysis. And basically what it says is that if the problem with the case is that there's a loss of important evidence, then you have to look at the two parties and decide, well, as between those two, who was in the better position to have preserved the evidence? Almost always that will be the claimant side, not the defendant side. And if it's the claimant side, then the court will also look to, well, is the evidence gone because of some inexcusable delay on their part or on their predecessor's part? And so it's an important defense. Pierre mentioned the relatively recent enactment of the HERE Act back in 2016, the Holocaust Expropriated Art Recovery Act, which is a statute of limitations. It's a nationwide statute of limitations enactment. But there is, there has been an argument and an initiative to say that the HERE Act also abolishes the Latches defense. I was involved in a case called Zuckerman v. Metropolitan Museum of Art on behalf of the Met, and this question was raised, and the Second Circuit agreed with us that the HERE Act does not abolish the Latches defense. That's a different matter. And I think that was obviously the correct result. But again, for the reasons I've stated that ultimately for me go to this question of due process, I think it's an important result. And I think Latches sometimes gets a pretty unfair connotation and a bad rap in these contexts. The other, aspect of let me just stop sharing this. Okay. The other aspect you see from the HERE Act is, so again, this is a statute of limitations enactment. It specifically says it does not create any cause of action, but you are seeing an initiative to extrapolate a substantive right out of the HERE Act. And the way I liken this is you can look to other jurisdictions. There have been examples of countries, particularly in Europe, who have enacted laws through their legislatures that basically nullify or presumptively nullify any transactions that involved Jewish owners of property, including in particular art, during a period of, during the World War II period or Nazi regime. In Austria, there was something called the Nullification Act or the Nullity Act. And again, it creates a rebuttable presumption that if art left the possession and ownership of a Jewish owner during the period following the Anschluss in Austria, that was presumptively taken by duress, and it should presumptively be given back. The US has never enacted a statute like that. The HERE Act is not a statute like that. But there is an initiative to, as I said, kind of extrapolate a de facto nullity act from the HERE Act. And I question, whether that's, it will ultimately be for the courts to decide whether that's a winning argument or not. I think as a statutory interpretation principle, it's not. But I think also courts are going to struggle with the proposition that, is this the proper role of the courts to do that? Effectively, this was in the Zuckerman case as well. What you will find yourself involved in, and I think this might be kind of the next line of these big cases, is what happens if you've got a Jewish owner in the 1930s who parted with art, but not under a strict definition of duress, wasn't forced at gunpoint, wasn't arrested or anything like that. It wasn't a forced sale to a Nazi or a Nazi agent, and it wasn't below market, at least for the times. And yet it was done during a period where, indisputably there were very, very hostile, dangerous surroundings, and the owner perhaps was selling the art to raise funds to flee. And it becomes kind of this argument of duress by circumstances. And I think that's what the courts are being asked to address particularly based upon the legislative history and some of the arguments made about the HERE Act. And so again, I think that this presents problematic line drawing questions for the courts that I think you'll see a reluctance for them to get into. I'm just going to read, this is from a brief I had written on this topic. Political strife and war abound in history and are not limited to World War II, as to periods of widespread economic urgency. For example, the Great Depression, the Great Recession, Bernard Madoff. Nothing in New York or US law embraces the notion that sellers or heirs of sellers may presumptively unwind otherwise voluntary transactions because those transactions occurred during difficult economic or geopolitical moments in time. And so the point being that you can always look to situations where people have sold property, sold art to raise funds because they feel some sort of pressure. They wouldn't have done it otherwise. Is it the role of the courts to come in and say, well, look, the Holocaust is just different. That kind of pressure is simply different. And so we're going to expand the legal definition of duress to embrace those kinds of transactions, but not necessarily other forms of economic or geopolitical duress. And I think that's the line drawing question. Just continuing what I'd written in the brief, nor is it the place of the courts to single out only one particular historical context to fashion a new kind of presumption of duress by circumstance. And that's really the question. You know, I don't think there's any question that if the Congress or any legislature wanted to come in and carve out, go through its constitutional fact-finding rights and powers and make findings that, look, the Holocaust is different. And we're going to pass a whole body of law. We're going to preempt the field, and we're going to create a cause of action, and we're going to even create a nullity act. Congress has the power to do that. But where Congress has not done that, should it be the place of the courts to do it in their stead? And I question, just on judicial principles, whether that's proper or not. And if they do that, what kind of precedent does that create in other contexts? What are the unforeseen consequences of such decision-making? I think you saw a version of this concern come out of yesterday's Supreme Court arguments involving the governments of Hungary and Germany. And those dealt with questions of international comity and sovereign immunity. But I think what you saw was a lot of questions from both sides of the political aisle on the bench, if you will, questioning whether it's the role. I think Justice Alito pointed out, we have 700 federal judges. Is it the role of 700 judges to decide these kinds of situations, or is it the role of legislatures? And more particularly for these cases, is it the role of the, in our case, foreign body legislatures, restitution panels that they have established, legislative regimes that they have decided make sense for those countries and their public policies? And I think you see the court, through a lot of its questioning yesterday, concerned that perhaps we really should leave this to that kind of legislative and internationally legislative sphere and take it out of individual judges' hands. I think that if you leave it to individual hands, you do run a risk of very subjective and unstable results. And I don't think that's what any of us who practice law believe should be the right outcome. The law should provide some sort of order and stability and hopefully predictability. So these are some of the broader legal issues that I just think are important to keep in mind in these cases. It is what attracted me to representing the defense side of these cases. I don't need to pad on to the overwhelmingly compelling reasons to prosecute on the claimant side, as Monica and Pierre have already presented. And so thank you very much. I will hand over now to you, Kate, as the host.
Well,
Thank you very much. I was just about to say, I'm gonna switch over to Tom. Tom, do you want to lead the Q&A?
Yes, thanks to William and Pierre and Monica for not only perspectives from three different directions, but also from three different levels of personal experience and approaches to these difficult restitution cases. And what I'd like to start with is to see if Monica or Pierre or William have, since William went last, maybe Monica or Pierre have some comment in response to what someone else said.
Monica, do you want to start and then I'll pick it up?
Can I just make a quick comment? Sorry. I just want, Bill, thank you for your remarks, and you raised a lot of obviously interesting and important points. The one comment I wanted to just quickly make, and I was happy you mentioned the Bacalar, example, is that it's a perfect, it actually shows sort of inherent in Nazi era art claims, that it's sort of a complex mix of the legal, commercial, and the ethical. And the only thing I wanted to point out is, which was sort of an interesting circumstance, is after resolution of the Bacalar matter, the Sheila in question in Bacalar was sold at Sotheby's on I forgot, it was several years ago. And as luck would have it, we had been, or as coincidentally, we had settled at Christie's while I was there, a matter involving a Sheila also with a Grunbaum provenance. And we had actually settled it sort of in some sort of amicable settlement, terms are confidential, which involved ultimately a sale. The sale at Sotheby's for the Bacalar work and our sale sort of the following day, back to back in the same year, the same season, the work in Bacalar, the Sheila, sold basically at its low reserve, and the work, which, and again, in the Bacalar matter, I think it was viewed as sort of having been resolved on its sort of on procedural grounds rather than a real focus on the merits. We had settled our Grunbaum matter with a focus on the merits, and our work, or the work that was being sold at Christie's at the time, sold for 3 times its estimate. So just to show, and just really as an example of the issue of sort of the commercial viability of these works, and how one factor in all of these cases too is at the end of the day, when you're working on these cases, and if you want to maximize the commercial value of a work, it is important to get to the merits if you can, because otherwise the reality is it's perceived as having sort of a cloud on its title, and people won't bid for it in an enthusiastic way if they perceive that maybe the case was dismissed on procedural grounds rather than a real focus on the merits. I just wanted to make that point, since you mentioned the Grunbaum matter.
Pierre?
It's not to weigh in on the facts, the pros and cons of the case or anything, but just the reality of the commercial sort of reality with regards to all of these cases.
Sure. So let me pick up on a couple of points and actually try to merge it with, I think, one of the questions that was raised in the Q&A about the technical defenses. Kate, I'm not sure if it's question 3 or 6, but I think that it loops well into this discussion. First, I sit on the ethics committee at the New York County Lawyers Association. Every lawyer is supposed to take ethics concerns very seriously. And let me tell you, when I managed the ethics hotline once, 30 days out of the year, for lawyers that call in with ethics questions, you see quite a bit of struggle with very complex and sometimes dramatic questions popping up. And clearly, this is a field that calls for that. I can only speak for myself. I cannot speak for everybody on the plaintiff's bar on this, obviously. I don't intend to do that. I don't want the audience to leave with the impression that lawyers that do this on the plaintiff side are a bunch of vultures trying to do a quick buck with a bunch of haphazardly amassed historical records, if any. If anything, the very first issue that I think I raised was the necessity for each side to try to figure out what the historical record is. And frankly, there is a lot of work still to be done on this. So to some extent, the historical uncertainty calls for still a lot of research work to be done. There's been an awful amount of work that has been done since 1998 across Europe and the United States, but there's still an awful amount of, this thing is not over and it will go on for a while. I think one of the questions was about the amount of, is this going to go on for a long time? I think yes, just because, how many more girl lit are there going to be? I don't think girl lit is the last girl lit. There'll be plenty of, girl lits popping up. So I think the notion that, lawyers are ethically exposed if they file frivolous claims. So, there's as much, I think, technical requirements or technical procedural obstacles for the plaintiff side. Obviously, the ethics and the malpractice risk is there like for everybody else, number one. And number two, they actually have to themselves face the plaintiff side has to face the technical defense. It's called okay, so the technical defense is, for the audience, things related to statute of limitations, failure to make a claim, all sorts of, essentially a motion to dismiss stage that look at a lot of the procedural questions before you even get to what happened in terms of the fact. This is, I think, for everybody, what technical defenses are, which is essentially something that is very much part of the US system. Obviously, having been educated in Europe, I can feel for the European side that don't understand why there's so many grounds to file a motion to dismiss in the United States, but just, okay, so that's the way the system works. I wouldn't be the first one to criticize the barrage of technical defenses that are being produced in the United States, because that's what the system is about. And if the United States, which in fact, at some point in time considered a commission system equivalent to what's going on in Europe, was actually weighed at some point in time several years ago. I think Eisenstadt was producing or was trying to formulate a commission type system similar to Europe in order to, in fact, shortcut or get around or eliminate the debate about technical defenses. Be careful what you wish for, you may get it. I'm not so sure the European side is necessarily that more efficient than what the US side be. It's just, it's hard to, I think it's hard to take the debate from the standpoint of technical defenses are unfair. They're unfair, yeah, because that's what the system is, and that's the burden that one has to go through to make a case, which, by the way, is a significant obstacle for the plaintiff side to overcome to even get any kind of merits discussion. Commissions in Europe, I mean, I think the Dutch example that I think, Monica, you mentioned earlier, no, that's right, in a previous discussion, shows that, they're arms of the government. It's the government that owns the art. So I don't know if it's certainly the best or the most optimized approach. It certainly makes for a discussion that's not about whatever number of criteria you can throw into a motion to dismiss, but it's not necessarily something that is the panacea either. So if that debate ever comes back in the United States, I'm not so sure it would, advocate for such a simple, way out for in terms of the of getting out of this technical defense debate. Kate, I think there was another question that.
Yeah, if I could just say, I would just say that good research, is fundamental to resolving disputes, basically. And there will be a lot more. I mean, we haven't seen the end of this. There's more research happening all the time. Archives are opening up. There's efforts to, centralize information. There's going to be a lot more sort of facts coming out. And also you have sort of the enthusiasm of the second, third, sort of fourth generations who are keen to pursue these claims and reconnect perhaps with their families. I think what would be very helpful is, because I don't think litigating these cases is the best way to resolve Nazi era disputes, is to really, and this is nothing new, it's something that I've been sort of talking about for years, and I think Tom has as well, is, you know, creating some sort of standards or some sort of uniform framework for looking at these claims. And perhaps we could, you know, restart sort of that discussion with a real focus on the facts again. Because, I mean, the reality is, I mean, when you're litigating these cases, I mean, again, a lot of what we're talking about are not the Klimts or the Sheilas or the Picassos. I mean, we're talking about a lot of works that have sort of a much lower sort of monetary value, and the cost of litigation, you know, will far outweigh the value of these works. I mean, just look at the Herzog Simon case right now. It's been litigated for 10 years. So I really just don't think that's the right way forward. And if we can sort of create some sort of, again, a mechanism, standards, you know, some sort of a framework, I think we could really, you know, move forward with regards to this issue.
So, Bill, any response, particularly on the issue of lack of standards and uncertainty, legal uncertainty in the area?
You know, what did Churchill say about democracy? It's the worst system in the world except for all the rest. You know, I'm not sure where. I guess that kind of dovetails into the point I was making before, that if Congress wants to come in and exercise its fact-finding and legislative power to do that, it can. And I think that in the broader scheme of providing certainty, that would be a good result. You know, the reasons why Congress has never gone that far, the reasons why the HERE Act stops where it does, I think is more a question of lobbying, of the fact that the art market is as Monica pointed out, a commercial market. There are commercial ramifications on both sides. And we are, in this country, a capitalist country. I think it's going to be very hard to develop enough political will and consensus to implement something like that. But again, you know, as I said, I think the objective is to try to get some stability in the law. And stability, I think, is a good thing, you know, in and of itself, as long as the procedure that comes out of it is thoughtful and a correct procedure that does indeed balance the rights of the current possessors.
Well, we all know that World War II and the Holocaust ended some 70 years ago or more, and we've been litigating these issues since then very intensely in this country for the past 25 years, and there's still enormous uncertainty. Bill, I come back to the question you asked about, is the Holocaust different? That was one of the questions before the Supreme Court yesterday. Is genocide different from other domestic wrongs that normally are the business only of that country? We have some interest in a question. I know, Monica, it's not your field since you were not involved in international disputes in the same way, but Pierre and Bill, perhaps you want to comment just a little bit, let people know what issues were in front of the Supreme Court yesterday and what you make of the arguments.
Bill, you want? So,
Well,
okay, so yeah, all right, so it's one of those things, you know. I think I started talking about lack of stability yesterday showed chaos, basically, even though I think we can all make certain bets as to what may occur in terms of by June when the decision comes out. So there's two sets of questions. One is the FSIA doctrine and the other is the committee doctrine. Bill, I'll let you take committee because we actually filed a amicus brief on behalf of a client regarding the expropriation doctrine. For the audience, if on the plaintiff or the defendant side, a governmental unit is involved in a cultural heritage case at large, because you can actually see the FSI doctrine come in even for looted antiquities when the country shows up at the door now and get thrown back on FSA grounds in terms of its actions. There's two legs to this. One is what's called the commercial exception. The other is expropriation exception. So you cannot sue a foreign government in U.S. courts unless there's a whole bunch of things going on. But for purposes of cultural heritage, two of them are typically coming out. One is the commercial exception, which is what occurred in the Altman case. And here that one appears to be relatively, let's say, less unstable, even though it's still a bit of a nightmare to try to argue where the line is. And I think what was at issue yesterday was the extent of the expropriation exception and to what degree the expropriation exception also applies to when the expropriation takes place against by a government against its own citizens. We'll see what happens. It's one of these things. I'm not going to make a bet, but that's how complex and delineated these issues can get. Tom, you had your share of technical questions to go after or to defend on all sorts of other considerations with defendant structures and legal histories and the like. So that's just another example of how difficult it is. I think one question was about how you make the assessment initially when these legal doctrines are all over the place. I'll tell you one thing. When you do a legal assessment at the beginning, it's really a total risk picture, because you know that if you have X amount of issues to litigate, it will mean X amount of times going to a circuit court, X amount of times of procedural issues that may have to be resolved. And it's part also of the financial picture on how you finance the case and how you you find creative ways to approach it. It's a total risk picture that you have to look at. It's not just such and such legal doctrine that has to be resolved by within a year, because it's not, you're not gonna have that. You should only make a risk assessment initially based on the totality of everything that comes into the picture and the uncertainties associated to your own risk. Every risk has the strength and the weaknesses, every single one. And then you make the assessment with, what the list of strengths are on the other side of the ledger. And that's what a good intake, program ends up being in a law firm. Go ahead, Bill.
Yeah, I thought the Hungary case, the arguments were quite expansive. The issues were expansive, but I think the Hungary case sort of boiled down to this question of comity, which is basically harmonious international relations. And you had the government of Hungary saying, look, we want to handle this we've got a regime in place. We've got restitution boards. Let us handle this. And oh, by the way, if we lose, it's going to be like 40% of our country's GDP or something. And I think Justice Kagan pointed out, well, that would seem to implicate international relations. If a US court were to take that case and hold against the government of Hungary and wipe out nearly half of its GDP to satisfy a judgment, that might cause some international friction. And I think that's really the core concern in the Hungary case. In the Germany v. Philippines case, as Pierre said, it's this really a question of sovereign immunity. And I think, again, at core, if you've got a country that has tyrannized its own citizens within its own borders and caused harm within Germany, do US courts have jurisdiction over that state of affairs and that kind of a transaction? And I think there, one of the concerns the court has is, well, let's flip it around. What if you've got a situation of the US administration tyrannizing some group of US citizens in the borders of the US and causing harm in the US, and their heirs or relatives decide, well, we're going to take the US administration to court over in, Pakistan or wherever. Is that something we want to effectively encourage by allowing a suit here? And that really is a very essential question of sovereign immunity and what does that mean? You certainly don't want to get into the business of predicting these cases or results. That the arguments did go on for a long time. There were a lot of questions, thoughtful questions, I thought, to both sides. But I think those are the concerns the court has.
Well, we have a terrific question from a superb German colleague who raises a level of discussion perhaps to the difference between litigation and negotiation of these cases. And I have noticed when I work with European lawyers, they're much more conscious of the Washington principles than we are, perhaps because there haven't been legal remedies in Europe and the cases have to be worked out on equities. The question really is, what's the status of the Washington principles in the United States? Since they're not law, they were intended to affect museums. There's no comparable principles for collectors, but the Washington principles still remain the best practices. Exchange information, make your files available, do research, try to work out an equitable solution. So I'm sure, Monica, maybe we start with you. What do you think is the status of the Washington principles? They were probably played big in your practice.
Yeah, they have. I think the issue with the Washington principles, it was a wonderful start. 1998 was a long time ago. And I think the reality is they were broad. It's what could be agreed at the time. And it provides an excellent framework. But in terms of implementing and what exactly is a fair and just solution, it has led to a lot of uncertainty, as we've been sort of discussing here this afternoon. I think as I was listening to everyone's discussion, and Pierre raised sort of what's gone on right now with the Dutch Restitution Commission. I think it's going to be very interesting to see if the pendulum swings a little bit back to Europe in terms of a more favorable sort of forum for dealing and resolving some of these claims. I mean, I think that the Limbach Commission in Germany, which is a commission that addresses these claims, has never had so many claims in front of it right now. I think the Dutch Restitutions Committee is going to be reconfigured in some sort of a way. And I think what we're left with here in the US, I mean, we have a number of pending, huge cases, but there's a lot of uncertainty. And again, I go back to sort of the earlier point that maybe we need to follow up maybe with the principles and create some sort of standard, some sort of uniform threshold for making claims, perhaps relook at it again and maybe sort of greater specificity to just have again to sort of deal with these cases in a realm of sort of greater certainty. Because right now it really is it's a bit of a free-for-all. I mean, a lot of claims are getting resolved. I mean, within the art market, the Holocaust Claims Office. I mean, there's claims being resolved, but it's very fact specific, and it very much just depends upon the parties, the political situation, the value of the work. I mean, there's no real roadmap. So that's my answer for the moment. I'd love to hear what Bill and Pierre have to say, or you, Tom.
So the question has to do with the Washington principles. So from the litigator perspective, purely from the litigator perspective, they're useless in court. It's as simple as that. They have no, this is not what you use to make an argument. You have a mix of state law, federal law, and obviously, a lot of these cases, interestingly enough, have moved from the civil sphere to the law enforcement sphere, it appears, which gives you an indication as to what the legal leverage ends up being when you have these cases. There could also be another factor here at play, which is that there hasn't really been, these, to go back and reinforce what Monica was saying, it starts with research, and it starts with the archives, and it starts with, the historical work. The next time another sphere of archives will be open or accessible, it's typically how, the next wave of cases get to just, come to fruition. So that obviously is a factor. But from the standpoint of the litigation sphere, I mean, the Washington principles are not a factor. In mediation, if the mediation is the result of litigation, I don't think it makes that much of a difference. If you're completely in the outside of litigation, obviously that's for other professionals to discuss.
Yeah, I don't think there's any dispute that the Washington principles are aspirational. I think there is an initiative to make the HERE Act a delivery mechanism that would codify or effectively codify the Washington principles, since the HERE Act is rooted in those principles in some part. Again, I don't think courts are likely to go that far as to say that this is an effective codification of the principles. But I think that there is an attempt to breathe additional life into them through the HERE Act.
So we have a lot of good questions, but we're over our time. Let's try to make this the last one perhaps, and roll up some of these ideas into one. Where do you see this area of Holocaust restitution going over the next 5, 10, or 20 years? Pierre, you were talking about second and third generation. I assume by then we'll be talking about the fourth generation. Evidence will be harder to come by. Maybe standards will be clarified. What do you folks see coming in the near to midterm? Monica?
I mean, I just see I see a rise in these claims. I see there's just more and more research being done, more students wanting to sort of get into this area with great research projects that are being funded by various governments. And again, many people or second, third generations of Holocaust survivors who are very interested in pursuing their family's legacy. I think what's interesting is it's not, I forgot who brought it up sort of in the course of this discussion, in terms of, or maybe it was in terms of sort of the Latches discussion this night. I mean, I think that the reality is you do have, it was, for that first generation, it was an absolute impossible thing to talk about. And for many of those survivors, just getting back property was not the number one focus. I mean, and to the point where it was actually became absolutely impossible to talk to their children, grandchildren about it. I think what's interesting is a lot of this information, archival materials in one way or another, is getting discovered. And all of a sudden that creates an impetus to, again, pursue these claims. And again, with additional research. And I think a key here is going to be centralizing a lot of this information. I mean, there's a lot of information coming out. It's fragmented. It's really hard to navigate unless you're an absolute, professional in this area. I think that we're going to see just a rise of these claims. I think what's really difficult, one thing I wanted to mention, is it really boils down to the facts here. And I think if you have a good handle of the facts, you can really find solutions. And the problem is this research work is extremely expensive. And I think that part of the issue in the US, I mean, you have the Holocaust Claims Office, which is wonderful, but you don't have sort of financial support for that research. And I think that, again, I forgot, Pierre, maybe you mentioned frivolous claims, or, I think maybe an issue is that claims are being brought that are not sort of adequately researched before they're being brought. And part of that is the fact that, this research, again, is very expensive. And not all these claims are for the sort of the big sort of Klimt, again, or Sheila, I keep using that example. And so there's a big cost involved, and that's been sort of a real obstacle. I think if we can get beyond that, I think it's in everybody's interest, frankly, current holders, claimants, museums, everyone, governments, I mean, to just really maybe find a way to fund, centralize this research. And I think that, and maybe create some incentives for current holders, and especially maybe some incentives for good faith, owners right now to deal with these claims once and for all. I mean, I think that the problem is I know, current holders who actually really want to deal with maybe a problem in their collection or a potential problem. I think, they're afraid of, there's sort of this fear of being almost associated with a tainted work or the attack that will ensue. And I think we just have to think about, creating some sort of, again, go back to sort of a new framework for looking at these claims.
Pierre?
Yes, so on the research question, I think Monica explained it very well. I don't need to, add to this other than to say that, again, the wave of cases comes from, is mechanically linked to the opening of sections of archives. It goes by, not everything opens up at once. You have to go literally, subsections by subsection sometimes, whether you're talking about the US archives or the European archives. Digitization is nevertheless a factor. When you start being able to cross-reference certain sources, it creates new opportunities. So that's the driver. And I totally concur with Monica on the claimant side. Tom, I just wanted to reassure you, we're still at the second generation level for now, since the second generation folks tend to be in their 50s to 70s. They typically, this is going to be the next wave. They typically split in two camps. The one camp that say, I don't know what the numbers are. Okay, so it's a 50-50. Okay, so 50% tend to say, heck, it's 75 years ago. I walk from all of this because I have other things to worry about. The other is the reverse. They tend to be very, very militant. So, who knows what the numbers are, but the second generation does not, some portion of the second generation does not give up. Who knows what's going to happen with the third? So.
Bill?
So I agree that these cases are going to abound, and they should, as more information comes to light, and as there's a real possibility of restituting those who've been wronged, that should continue. I think I agree with a comment Monica made about incentivization. I think that, a lot of this the courts do have an incentivizing or disincentivizing effect based upon their decisions. And if the court decisions that are coming out of this do ultimately, focus on the quality and existence of evidence, hopefully that will, I think, as Pierre and Monica both talked about, you really want to try to gather as much facts as you can. And if you're unable to, but facts develop through the case, you want to be, both sides really want to be honest about what those facts are showing. And if the court decisions tend to show that the courts are going to follow the facts, then I think that will help incentivize and disincentivize the way these cases go. And I think that would be a good thing. I'd also just throw out there that there's a new specialized art tribunal based out of The Hague called the Court of Arbitration for Art. And it handles all manners of art disputes, including restitution. And that could be a body, in the absence of an international restitution board, that could be a body that could be a useful international hub to develop a real specialty and body of treatment and rulings that come out of it that could be beneficial, across the globe.
All right, well, that's terrific. My thanks to the panelists for their thoughtful remarks, a lot of wisdom for everyone to absorb. My thanks to the audience for your attendance and interest, and my thanks to Kate for organizing this terrific event.
Thanks, Kate.
Thank you, Tom.
Thanks,
Thanks,
everyone.
Kate.
Stay safe, everybody.
Thanks, everybody.
Thank you very much, everybody.
Yeah,
Good luck. A
See you.
bientôt.
Yeah,
Ciao.
Ciao.
Wow.